Uganda has cleared the way for the treason trial of Dr. Kizza Besigye, an Ugandan physician, politician, and former military officer and leader of the president of the Forum for Democratic Change Party. Besigye and his co-accused Hajji Obeid Lutale and UPDF Captain Denis Oola face joint charges of treason and misprision of treason. The court yesterday dismissed a defense application to halt the trial. Justice Emmanuel Baguma rejected the defense's claims of human rights violations and unlawful abduction, labeling the petition a shallow abuse of the court process intended solely to delay the case. The court ruled that alleged rights abuses do not automatically terminate criminal prosecutions. We speak about this now with Jude Byamukama, who's a constitutional lawyer based in Uganda. A very good morning to you, and thank you so much for speaking to us.
Good morning. It's always a delight to speak to you about what's going on here in Uganda.
So, what are your impressions about what is going on, given the statements by the judge who promptly rejected the premise of human rights abuses, illegal abductions as a premise not to even begin with the trial? Do you believe that these individuals, particularly Dr. Besigye, will get a fair trial?
I think it's for us looking at how this trial has unfolded over the past several months. It is very, very questionable whether Dr. Besigye can get a fair trial. Frankly speaking, I do not think he is going to be able to get a fair trial. One of the most difficult issues now is that a few weeks ago, his lawyers were subject of harassment and intimidation from the military. And as we speak now, he does not have any lawyer on court record because most of his lawyers have been intimidated and have chosen to opt out of representing him. And yesterday, the trial judge, Justice Emmanuel Baguma, made an order that the state should provide lawyers for Dr. Besigye. And that is a very absurd development because Dr. Besigye can't afford his own lawyers. And a charge of treason by its very nature is about the interests of the state against an accused person. And then to have the same state being the one to now get counsel for Dr. Besigye, not because he cannot afford his own lawyers, because that's what the Ugandan constitution provides. An accused person is only entitled to a lawyer on state brief if they request for one because they cannot afford one. But now we have a situation where a trial judge is directing that lawyers be imposed on Dr. Besigye to represent him and his co-accused without their consent. Obviously, what we are witnessing is a mixed trial. It is impossible that Dr. Besigye can have a fair trial with his co-accused when they are unable to have lawyers of their choice. The trial court has disregarded all the human rights concerns. And by the way, under Ugandan law, a ruling on human rights concerns is appealable up to the Supreme Court. And I probably expect that Dr. Besigye and his co-accused will be filing an appeal over that very point. But the trial judge seems to be hell-bent on subjecting them to a mistrial. And it's really unfortunate. But that's what we see unfolding. In terms of the Ugandan constitution, the right to a fair hearing, which is really the right to a fair trial, is non-derogable. In other words, there are absolutely no exceptions recognized in the Ugandan constitution where an accused person can be tried in disregard of his due process rights. But we see the trial court clearly taking the view that whether Dr. Besigye is going to receive a fair trial or not, the trial judge is minded to subject him to a criminal trial of some sorts. That's a very unfortunate development. It obviously violates and we continue to watch and see how this trial unfolds.
And as you mentioned, that at the heart of this is the state's interest, and I wonder from a constitutional law perspective, does it constrain, does it recognize the conduct of the state against those of the criminal accusations made against the accused, because this does seem to be a referendum on the constitutional order of Uganda.
Yes, in a sense. And by the way, we have been in this situation with Dr. Besigye before. Between 2005 and 2006, Dr. Besigye had been charged again with treason and terrorism, and eventually the Constitutional Court intervened after Dr. Besigye's lawyers petitioned the Constitutional Court over the violation of their due process rights pending trial and in the course of trial. And the Constitutional Court declared the trial a nullity. And as a result of that finding of the Constitutional Court, eventually the Ugandan Parliament enacted the Human Rights Enforcement Act. That was a law that basically provided that if the non-derogable rights of an accused person are violated in the course of a trial or before trial, then the trial must be declared a nullity immediately. And that legal principle is recognized in the Ugandan constitution. But to our surprise, a few months ago, the Uganda Constitutional Court made a U-turn and overruled its previous position indirectly and ruled that an accused person, even if he or she is a victim of violation of non-derogable rights, that alone does not mean they cannot go for a criminal trial. It's a very absurd and laughable ruling, and that's the ruling which the state is relying on to try to begin Dr. Besigye's trial. That ruling from the Constitutional Court is being appealed. I'm part of the legal team. We are appealing that ruling to the Supreme Court. But now we are faced with a very strange scenario where the Constitutional Court is basically saying the state can violate the due process rights of an accused person, but that does not have any bearing on a criminal trial. That's a very absurd development, and it's negating over 20 years of growth in the constitutional dispensation in this country. And we are extremely worried that our legal system is degenerating into a circus when it comes to criminal trials involving political opponents of the government of the day.
And I'm just wondering, how do all of these unresolved questions, both for any ordinary Ugandan citizen who comes before the court, who doesn't even have the high profile of Dr. Besigye?
And yeah, that's what part of the problem, because the treatment that Dr. Besigye is receiving is not new. There are a number of numerous accused persons who are in prison without even being tried. We have some young political activists, many of whom are associated with the leading opposition political party, the National Unity Platform, who were charged in 2020, 2021. Some of them were charged before the military tribunal, which in Uganda we call the court martial. Then later, the Supreme Court ruled that those trials were unlawful. After the Supreme Court ruling, that was last year in January, the civilian courts declined to proceed with any criminal charges against those activists. And the state they have doesn't them up to this day. So we have people in Ugandan prisons who are not convicts serving a prison sentence and who are not accused persons before any court of law. But they are in prison, and some of them have been in for more than 4 years. It's a very absurd development, and it doesn't augur well for the future of the legal system in this country. So it is true. But that having been said, we have a double-faced legal system. When it comes to the ordinary individuals, the quality of justice that they get before the court, they are well represented, is much higher than what Dr. Besigye and his co-accused are going through. So our legal system still has elements of fairness for some individuals. And then there are others, especially those whose cases have political undertones. They are not receiving any fairness before the courts of law. They are denied bail, even when the Ugandan constitution requires mandatory release on bail. If a person spends more than 60 days or in pre-trial detention on a non-capital offense, before trial, the constitution requires them to be released. And if a person is charged with a capital offense, like Dr. Besigye, if the trial hasn't commenced within 180 days, they must be released on bail. That provision, which is Article 23, Clause 6C, Article 23, Clause 6C of the Ugandan Constitution, required that Dr. Besigye should have been granted bail many months ago,
Okay.
because he has been in pre-trial detention for quite some time. But the judiciary has chosen to disregard the constitution of this country, and yet the judiciary, the courts of law, are the ultimate custodians of the constitution.
All right.
And therefore, we are in a grave constitutional dilemma.
Jude Byamukama, we're going to have to leave it there, but thank you so much. Jude Byamukama is a constitutional lawyer based in Uganda, speaking about the upcoming trial of opposition leader there, Dr. Kizza Besigye.
African Diaries with Teach Mataz. Catch it on the Channel Africa app, SABC Plus, and on channelafrica.co.za.